Hey, I have the pleasure of introducing you all. We have Jennifer Yim from the Board of Pardons. Jennifer MJ Yim is the Director of the Administrative Services at the Utah Board of Pardons and Parole. Ms. Yim has experience in a variety of roles in Utah's justice system, including having served as a parole board member in the juvenile justice system, a member in the merit selection process of judges and magistrate judges at the state and the federal court levels, and as a founding commissioner and former executive director of the Judicial Performance Evaluation Commission. Ms. Yim has a doctorate in political science and a master in public administration, and both from the University of Utah. And then we have Shanna Wyatt. She has been working for the state of Utah for 24 years. She came to the Board of Pardons 19 years ago and has worked in various positions since. However, she's been the victim coordinator for the majority of 19 years. And over the years, she has served on the planning committee for the annual Utah Victims Crime Conference, and she has also served as a member of the Utah Council on Victims of Crime and has presented on behalf of the board at several conferences and training events. And we also have Brett. Sorry, I had to pull it up over here. I do have your information. Brett Burrows, he's a chief hearing officer at the Board of Pardons. Thank you and welcome, and we appreciate your wealth of knowledge and presenting to all of us today.
You're welcome.
Thank you for having us. I would just maybe expand a little bit on Brett's bio. He is our chief hearing officer, as Beatrice said, but he is also the person who knows the answers to every possible question at the board. So he's here for obvious reasons to help us give this presentation. Well, it's really nice to be here. Thank you both very much, Beatrice and Vicki, for inviting us. And hopefully we can continue your day of working through some of this case study and being able to use that as a way to talk about what would happen. So as I understand it, the way you've worked through this, it ended up as a Class A misdemeanor, which of course wouldn't implicate the board at all if it were a standalone hearing. But maybe we can just pretend it was a third-degree felony aggravated assault, and we can talk through that through our process. And there are some new parts of our process that we're going to be really excited to to share with you today. Brett, do you want to start? Do you want to make reference to the case study and show our slides? Do you think that would be helpful? Or do you want to just talk about the case, your preference in terms of presenting some of this scheduling review and other information?
I mean, I think it'd be okay to show our slides and then talk through kind of in that scenario that you just talked about, this is what would occur. And I wanted to mention too, I believe Amanda is on as well.
Great.
Yes, I am. Yep.
I just thought I wanted to make sure we knew she was here.
Great. Will you introduce her for me while I get this presentation up?
You bet. Well, and Amanda, do you want to just introduce yourself, or would you like me to?
No, I'm happy to introduce myself. So my name is Amanda Robinson. I've been with the board for 11 years. Prior to that, I come from adult probation and parole, where I spent about 7 years.
Okay. Did I successfully share my screen?
You did.
And it looks
yeah.
the right.
I want to echo Jennifer that Brett is just the know-it-all of the board. Like, he knows everything.
I'm just a know-it-all, that's all.
Okay, so we put this together, this presentation together for a number of different presentations, but I just wanted to start just by saying, our goal really is we want to make sure that we understand what victim advocates do in the community, that we understand the important job and role that they fill, and we want you to understand what happens at the board, because I've been in this position for just over a year, and my sense is that sometimes the criminal justice system can feel incredibly disjointed. To victims, the criminal justice system isn't centered around them, and so they can easily fall through the cracks. And a lot of them that I've spoken to thought that once sentencing happened and the court process was over, they would be done. And really what they find themselves in is a position where they feel like they're starting all over again. And that doesn't sit well with me. And I think that there are things that the Board of Pardons can do to help ensure that even though many of you are working in the prosecution phase and in the court phase of that process, the law enforcement phases, there's ways that the information that you provide to victims can help them as they move through the system. And I just want to make sure, because to the extent that we don't make those efforts to make those connections, it really is the victims who are suffering. So our goal is to be trauma informed, to make sure that when they move from sentencing to post-conviction, that they don't have to necessarily tell their entire story again and again and again. So we want to create the kind of system that serves people better in Utah. And some of the new processes that we're going to be describing here today covers some of those new processes. So let me also say we're also willing to answer questions anytime you have them. So just unmute and feel free to ask your questions. But we'll start with this case study and move forward talking about one thing that should be relatively new to all of you. And that's how we schedule someone for their first hearing before the board. And I'm going to let Brett talk through that first part. Oh, wait, I'm letting Amanda talk through that first part.
Okay, so yes, we have changed the way that we schedule our hearings now. When somebody is committed to prison, the board determines the date they have their board hearing within 6 months of the date that they're incarcerated to prison, the day they're committed to prison. Within that 6 months, what happens, we complete our sentencing guidelines, our case analyst team. The board will set expectations for individuals, if it's programming or reports that they would like to see prior to that original hearing. Then it will go to Shanna in some cases to notify victims depending on when that hearing date is. So yes, I think I hit all those marks. This has changed tremendously from how we used to do it. Prior to April 1st of this year, depending on what somebody's commitment crime is, that's what determined the date that they would have their original board hearing, which did not set realistic expectations for a potential release. So switching to our new policy on how we schedule really gives a more realistic time frame of when somebody potentially could be released on a parole.
Okay, so let me just underscore some of the things that Amanda said. So when this person would arrive at prison on that 3rd-degree felony aggravated assault, under our old system, when would that person come up for a board review of their first hearing?
Yeah, so in that scenario, on the ag assault 3rd degree, our prior rule, they would be heard within 3 months of commitment. And now, in that same scenario, how our current rule is, the board would receive all of the information, guidelines would be completed, and then the board would set a more realistic original hearing date based on what those guidelines are.
Right.
So a lot of it is guideline driven instead of charge driven or degree driven.
And to that point, in that old system, that 3-month date for that 3rd-degree felony aggravated assault, on the matrix, it's going to be a 3rd-degree person crime. And that guideline date for that is probably going to be in the area of 36 months. So in this example of you're having a hearing at 3 months with a guideline date at about 3 years. So really the chance of someone being released at 3 months is really not unrealistic, and that victim's having to go through that hearing process, more than likely to have another hearing set out in the future. And in this new process, part of our goal is to set a more realistic hearing date for all the parties involved and what may be a potential release. And as Amanda said, set those expectations for what the individual should be doing prior to that hearing.
So one of the other things that is positive about that, and I think it's easy to see how we're setting expectations a little bit better, right? We're not having to call people into a hearing and say, oh, really, they're not going to get out. Don't expect that. When it is still a potential result of an original hearing before the board, it's always a possibility. So now that hearing for this person, instead of being at 3 months, would be, maybe not 36 months at guideline, but backing away from that guideline a little bit. But one of the other reasons that we're doing this, that we think will help the system function better, is that we will be setting those expectations earlier on, not just for the person who's incarcerated, but for the Department of Corrections. So as you may have heard, sometimes it has been hard, like since COVID, to get certain types of treatment in the prison. They're having trouble keeping staff in certain areas. And if we set those expectations up front, which would include, on a more serious crime, right, saying, okay, this person we're not going to see for 10 or 15 years, but before they come to us and we actually have that hearing, we want them to be done with sex offender training. We want them to be done with all of these assessments that need to be done. We want their behavior to have been appropriate. So setting those standards up front and those expectations will help the Department of Corrections to say, okay, so in year 5, we need to be able to have the staff available to provide this much treatment in these areas. Year 6, year 10, year 15, et cetera, which is kind of planning that the system hasn't had in the past. So we're hopeful that that makes it more likely for people to come before the board, understanding what they were supposed to do. And if they did it, there's probably a better likelihood they did it all, that they would get a near guideline release. And the expectations then, if they weren't met, would be more likely, obviously, to result in a rehearing, in setting a date out at some time in the future. So we think that new way of doing things will help us considerably. Shanna, is there anything that you wanted to say?
Yeah, I was just going to say on behalf of, for the victims, this also gives the victims the opportunity to figure out their next steps. It gives them a little bit longer, to heal. It gives them a little bit longer to get a safety plan in place if they need to do that. It's just a benefit all around. And it takes out an extra hearing step that victims don't have to go to.
And so did you want to talk about that 3-year thing too?
Yeah, so if the hearing is set out more than 3 years, we do offer to the victims at their request to have a victim impact hearing. So if that hearing is set out 20 years, the victims can ask for a victim impact hearing where they can come and get something on the record. It stays on the record and then it's reviewed at the time of their first hearing. I mean, people can send in letters anytime once he's sentenced and put in, under our jurisdiction. Family members or supporters of the victims can send in letters at any time. Everything that's sent to the board is put in his permanent file. But that being said, everything sent to the board is also disclosed to the offender at the time of the hearing. So we like, to victims to keep that in mind too, that everything that we receive, the offender does get a copy of.
Thank you. Does anyone have any questions about this new scheduling process? Okay. So when Amanda was talking about the new scheduling process, she started by saying that we were going to calculate the sentencing guidelines. And of course, we've calculated sentencing guidelines all along, but we're actually moving it up earlier in the process. Many of you, I'm sure, know probably a lot about sentencing guidelines, but I thought we might have Brett share a little bit about the unique aspects how the board uses them. So.
As Jennifer indicated, most of you are probably aware of the Utah Sentencing Commission, the guidelines and the matrices that AP&P uses. Prosecutors and others involved in the system can look at that and get an idea of maybe what possible timeframes are. One thing that as we've been involved in some of these trainings, some aren't aware that the board does not. We use the same forms, Sentencing Commission forms, but we do not use the matrices or guidelines that AP&P prepares for the courts. There's a couple of reasons why. Many times, if AP&P is doing that, completing that matrix, it's for a specific court, a specific case. If the board has multiple cases coming from multiple jurisdictions, we are going to combine those all and put them all on a matrix, and then based on the severity, one will be the lead offense that has get the full guideline, and then based on the orders of the court, either concurrent or consecutive enhancements will be added to that. And I don't want to offend anybody when I say this, but we have 3 dedicated staff, our case analysts here, that do this, do the matrix, do the time accounting day in and day out. One of the difficult things I know from my time at AP&P previous to coming to the board is you have, many PSI writers that are out there in the different areas of the state, and they don't do as many. And the rules at times can be complicated. Phil would tell you all very confident in our analysts that they do this day in, day out. They know the rules and they're very accurate in how they. Now, that's not to say that, our staff, we may make mistakes. And if we get challenged, we will review them, and occasionally we will make, those adjustments if we need to. But again, we do not use those guidelines or matrices that AP&P completes for the court.
Questions about that? So, maybe before we go forward, well, I guess you did talk about that. I was just going to try and apply this to the case study. Is there anything else we want to talk about with those? So we might say his 3rd-degree felony aggravated assault might be 36 months, but it might also depend on any criminal history, any other things that might previously exist.
Sure, and on that matrix that we talked about, again, there's usually 5 levels to it. So in that category, that 3rd-degree felony aggravated assault would be a 3rd-degree person crime, and the range on the low end, depending if they had a minimal criminal history, it may be, say, I'll just ballpark it, it may be 18 months, up to in the top in the 5th level, the highest level, it may be 36 months. So depending on their criminal history and where that intersects, that'll give you the guideline number of months that individual should serve, or it's recommended to serve based on the guidelines. Another important part about guidelines is no one is entitled to that guideline. It's really a recommendation only. I like to say it in my mind, and my recommendations that I make to the board, it's kind of a starting point. And then depending on, aggravated mitigating, I may recommend above it or below it. And ultimately it's the board's decision to either release below, at, or above the guideline. They are not binding on the board.
Okay. Thank
So
you.
in reference to the case, so if he's on a third-degree felony and now he's been sent to prison, and now we're looking at and scheduling his hearing. This is when a victim or a victim advocate would get in contact with our agency to make sure that we have an address, an email, any information that we're going to need to make sure that that victim receives 30 days notice of that hearing that's going to be happening. We want to make sure that the victim knows about that hearing, because this will be the first time that the victim will actually get to either in person, in writing, or video, talk to the board for the first time. So this would be the time when you would have your victim contact our office.
Okay. And credit for time served. We don't really talk about this person's history, I don't think, but can you talk a little bit about how you calculate the time, and maybe a little bit about how we're at how what we do differs from maybe what the judge's order might sound like?
That same group of case analysts here at the board do both the guidelines and matrices and this credit for time served review for each individual that's committed to prison. And really what Jennifer touched on is if the court, as part of the judgment and commitment order, makes an order or a recommendation regarding credit for time served, that is not binding on the board as well. And the board will, our analysts will do the review, and they will determine what, if any, credit for time served in jail prior to that prison commitment the individual is entitled to. And it's case specific. And one of the big differences that you see coming from the courts is many times the courts may just say, well, this individual has been in custody for 300 days and they're going to get 300 days credit on all of their cases. Well, our analysts will actually look at each individual case and review, was there a hold order for this case? And so the individual may get 300 days credit on this case, but they may not be entitled to 300 days on another case. So it's done, again, reviewed on an individual basis. It's days on electronic monitoring and a treatment program. They don't qualify for credit. It has to be incarcerated time. And that credit for time served, if it's granted. So like in this case, let's say the individual had served 3 months in jail prior to being committed to prison. That will impact both the front end and back end of his 0 to 5 sentence. That 3 months credit will reduce or lower his expiration date by 3 months. So the back end part of the sentence, it will also move the front end or the start date when we would calculate that guideline date. It'll move that front end date 3 months as well. So it impacts both. And again, as I indicated, the orders made by the court regarding credit are recommendations only.
So sometimes that might explain why someone with a relatively short guideline might seem to get out or have a parole hearing even sooner, right? Because we moved that date back because of the time served.
And it doesn't happen, I'd say, all that often, but there are even occasions when individuals who have been on probation, say this individual had been on probation for several years and had done, 2-3 years in jail in various stints. They will get credit for all that. And in some scenarios, by the time they come to prison, because of that credit, they may actually already be over their guideline. And so, that's just one of the realities that sometimes happens.
Right. So in this situation, for example, if he had 3 months credit for time served, it would move the start date back and he would enter prison already eligible for our old way of scheduling.
Correct. In the old way, not the new way.
Not the new way. And so maybe then that date for a hearing would be set out 2 years instead of 3 months. It's kind of the idea.
Yep.
Questions about that? I can attest to the fact, trying to learn the system, that it's more complicated than it seems. And it's can be really tricky to kind of get your head around. And I guess one of the reasons why I say that is, you know, we sometimes worry about being able to kind of predict what's going to happen when we send something to time accounting and to our case analysts. And even after we get somebody, it can be there can be a lot of unknowns anyway. And so just wanting all of you to know that in terms of how you might speak with a victim about a particular case.
I just wanted to mention in the chat, Jennifer, I added the Board of Pardon, that victim referral form that Cache County had created, made it a universal form. So people can, criminal justice advocates can utilize that and send that to the BOP victim at utah.gov so that Shanna has the correct, most accurate information for the victim, and also to Laura Flanagan so she knows that there's a criminal justice advocate involved and is aware of the case too. So you can use that referral form to let them know if the victim's registered for VINE, as well as if there's a victim impact statement on file and a restitution request, to include that, a copy of that, to the Board of Pardons, because they don't get that directly from the court.
Yeah, I think one of the things people assume, which can make life difficult for Shanna, is that we have a lot of information at the board and that we have victim information. We have counties that when they sent their county attorney packets to us, redact all the information in those county attorney packets about the victims, which often is the thing that leaves us in a difficult place, not knowing how to make contact with those victims. So this form might help. Shanna, if you want to share contact information or any other suggestions that you have about this.
I think that they just posted in the chat the BOP victim at utah.gov. Also Laura Flanagan is definitely a contact. The victim advocates all have my personal email if they want to email me personally. You can always call the office. There's BOP info at utah.gov also is another form. But the BOP victim at utah.gov is definitely the best way to send over statements. And then of course you can always call.
So one of the other things that we're doing is that we're in the process of creating our own victim notification system that eventually will let people go into a portal on our website to state their own preferences about how they want to be contacted and when they want to be contacted, when they don't want to be contacted, with information about a case. And we think that we see this as a board VINE alternative that makes an effort to provide that information in a way that's trauma informed and help make sure that people get information in the way they want to get it. So that's something that's in process. We're programming it right now. Shanna's working hard on that. Part of it should be implemented and up and running in September of this year. The portal, it will probably be by the end of the year that we're hoping to get that up and running so that people can go in on their own. And we will also make it so that victim advocates can enter that information on behalf of a victim. So,
and just a question in the chat was, why are the victim impact statements not provided to the board from the court?
So we're working on that. The easy answer is, I think a lot of people have made the same assumption over the years that the board has all the information available to it. And it's just not true. And so I think that was something that judges also assumed. But we are working on a new system connecting the information systems of the board and the courts so that when it's done, which hopefully will be this year, we will have information available to us, including that victim information, that victim impact statement, as well as some other information like the sentence itself, which we have typically gotten from the Department of Corrections, as well as some of the assessments that were done in the trial phase of the person who is now incarcerated. So we're working on it, increasing the quality of information available to the board, but it underscores one reason why we are so reliant on all of you to help get us the kind of information that we need so that our board members who want to take this information into consideration to actually have it available to them. Any questions? Brett, do you have any comments about indeterminate sentencing? I know we met yesterday with a lovely group of victim advocates from the Salt Lake District Attorney's Office and Davis County Attorney's Office, and some of them left saying, I didn't realize this was the kind of indeterminate sentencing system we had in Utah. And so it might just be interesting to kind of talk through some of these issues, either in the aggregate or with respect to the case that we've got.
Yeah, well, and you remember, I had to leave, or at least I didn't catch all that conversation about that, but certainly the indeterminate sentencing system that we have here, in this scenario, the aggravated assault would be a 0 to 5 year sentence that's imposed by the court. And we've talked about the guidelines, say ballpark for the conversation, say it's established at 36 months. It's not binding on the board. That time accounting that we talked about will set that maximum expiration date. It starts out once the prison admits the individual, the system will calculate a 5 year date from that date the person is admitted to the prison. Once our case analysts grant any credit, then that reduces that expiration date. The board cannot hold anyone beyond that expiration date. If when that date comes, regardless of where they're at, whether they're in the community, in the prison, they have to be released either from parole or from incarceration. Again, the board will set up concurrent consecutive sentences. I touched on this yesterday, kind of a bizarre situation with consecutive. Let's say in this scenario, if this individual had 2 aggravated assaults, they were both 0 to 5s, and the court ordered them consecutive. Well, technically, that second 0 to 5 does not start until the first one ends. So you have a 0 to 10 year sentence. If and that'll be calculated, incorporated in the guideline. If the board were, say, to release that individual at 3 years, technically speaking, that second sentence hasn't even started yet, right? Because it doesn't start until the first 0 to 5 ends. But as far as parole goes, they're actually on parole for both. So you could actually have someone that's terminated, say, from parole before that second sentence even starts. And that was a concept that I had a very hard time even wrapping my mind around when I came to the board and was working as an analyst, because how does something end before it even starts? But, there are no consecutive paroles. So that's why in that scenario, it could happen. But we talked about the board is not mandated or obligated to release a guideline. We can't go past the expiration dates, and dates can change. Like I mentioned before, if someone questions the scoring on a guideline and our analysts review it, and if they correct or change it, we will change that. And if it changes the expiration date, that information will be provided to the board, and they can adjust any decision they've made if needed.
How about those minimum sentences? This isn't something that happens very often, but it is possible for the board to release somebody prior to their minimum sentence, although it doesn't happen very often, but it might happen if the guideline is below the minimum sentence.
Yeah. And obviously it'd be difficult in the scenario we have today, but let's say if we change that and say the person had 4 1 to 15 consecutive sentences. So the minimum sentence based on that court order and that consecutive order would be 4 years. But that person's guidelines say potentially might be 40 months. And so technically the board can release below that minimum sentence. Again, I would, as Jennifer indicated, it's probably not a real common thing, but the board technically can do that.
So I guess one of the things that we hear, and I actually think that there are lots of reasons that we might hear this, is, victims saying to us in that situation, oh, we were told that this person would stay a minimum of 4 years. And that just creates kind of a difficult situation, right, of setting expectations. And so that's kind of one of the reasons why we're setting up these scheduling reviews, why we're wanting to have some of these conversations, why we want to just be really careful about the messaging that we're giving to people so that we know. We would love to be able to make those kinds of assurances when they exist. I'm just not sure they always exist in the cases that people are getting those assurances. So, Shanna, anything you want to say about that?
No, I think the only thing I would advice that I would give to any victim advocate that's talking to their victims about the length of time that an individual will do in prison is, unfortunately, we need to prepare them for a release. I know, do you get a lot of life sentences, but the reality is they probably will not do a life sentence. It's just better for everyone and their trauma if they understand the reality is going to be a release someday. And I know Laura Flanagan practices this with her victims. It's better to prepare for somebody getting released from prison than giving them the expectation that they're going to do another, 25 years, 50 years life. Just prepare them for that. As I think a lot of them only hear that end sentence, they hear life. They don't hear a minimum ever. They always hear a life sentence or that max. So just preparing them, you're doing them a good justice to prepare them for a release.
Any other questions about some of that?
I don't know if you saw-
Just one in, oh, sorry, just one in the chat was, I didn't mean to interrupt you, Brett.
Yeah, that's what I was gonna say, is there's a question in the chat, so.
Yeah, go ahead if you want to address that. So it's just, the question is, has there been any discussion about moving away from the I can't say that word, intermittent, I cannot say the word today, sentencing to judges handing down sentences at sentencing similar to many other states?
Sure, there always are conversations about them. We're not a mandatory minimum state, and we're not a determinate sentencing state. Sometimes there are conversations in the legislature to move that to for certain types of crimes or for all crimes. It's a tricky situation, and there are just lots of considerations, right? It may, I think for many people, it may seem more straightforward to just say, okay, well, if you're sentenced to 16 years, you're going to get 16 years, and that's just the way it is, and the doors won't open until you get to that 16 years. From a public policy perspective, we can absolutely legitimate places to stand are all around that issue. In this state, it would definitely mean building a whole lot more prisons, because the prison we just built is already busting at the seams, and we're talking about breaking ground on new, at least, units. So that is something that would require significant amount of change. The Board of Pardons and Parole is both a statutory and a constitutional entity. And so it would probably require, to go completely to the other end of that spectrum, a constitutional change. Okay, some myths. Do you want to talk a little bit more about Vine, Shanna? Anything else you want to say?
Of course. So the first thing I want to say is the board is not contracted at all with Vine. Vine does not notify of hearings. It doesn't notify of decisions. And the board does not receive any updated information through Vine. I know I get a lot of phone calls from victims that say, well, I registered with Vine. Why don't you have my address? Why don't you have my information? So I know that most of you, we've talked about this in other trainings, but I just want to always push that even though they're signing up for Vine, we're not getting that information, and it will not notify of hearings. That's probably the biggest thing. Also, how we get our information about victims, the best way is from the victim, of course, always calling us or contacting us by email, any way possible to get us their updated information. But we do count on a lot of county attorney packets and victim advocates to keep us in touch through the victims, because you definitely are the ones contacting them and talking to them more on a regular basis. Laura definitely has been a huge help in keeping contact between us and victims and victim advocates. So we definitely appreciate all of your guys' help. We couldn't do our job without you guys doing your job with the victims. So I just want to express thank you for all of you that do get in contact with our office. And we've already touched kind of on victim impact statements and where we kind of get those from. The victim impact statement that we really go off of, that we have, is from that pre-sentence report. That's the one thing that we do get consistently. And again, we don't get a lot from the courts, but we do get the county attorney packets, but sometimes they're just huge. They're in a separate area. They're not just sitting in his file or an offender's file. So they're not always getting reviewed if they are in there. So again, it's very important to get those statements directly to us.
Thank you. I'm kind of interested to know if there are things that you've heard about the board that you wonder whether it's true or not, or things that any questions that you have about our process.
I think one thing to people can look up an offender and know where they're at in their kind of the sentence. You can look up to see if they're in the prison and if there's been a decision made by the board. I think that knowing that that's public access and that you can look up an offender, a victim can look that up, an advocate can help a victim look that up. I think that's always really helpful to know. Yes, so Beatrice just put the link in there of how you can kind of search that information. And so that's something too, that letting victims know, empowering them that they can look up that information, I think is always helpful too, because I didn't always know you could look up everything. I could see them on Vine that they're in prison, but just to see all their decisions, if the board's made a decision, what it is.
And go ahead.
I was gonna say one caveat to that or follow-up is it that search only includes active individuals that are either in prison or on parole. So if they've been terminated or discharged, then at least for now, right, Jennifer, they don't show up on that search.
Yeah.
So past cases.
Yeah. We're working on updating that. And we are also working on updating our website. So the next time you go to our website, it may be different, but we're hoping to make improvements specifically to that search page to make it a little bit easier or a lot easier to understand and to operate, just to make our whole website more user-friendly and current in the information that we provide. So that should be done by in the next month, I would say. There's a great question here, and it was just one I was thinking about. I finally was able to see the question. So, is the way you think about board members is, you know, similar to perhaps what is, here, maybe I'll stop sharing so we can, similar to how you might think about judges. They are appointed by the governor and confirmed by the Senate, just like judicial appointments. However, they might be, but don't have to be attorneys. Some of them might have a background in law enforcement. We have right now, we have 4 board members and 1 appointment that is awaiting confirmation by the Senate. 1 is a former law enforcement. 1 is a former criminal defense attorney. 1 is a former prosecutor. And 1 is a former administrator with a background in juvenile justice issues and some academic issues. And so, oh, thank you. Rochelle just put up a link to the bios of our current board members. The upcoming board member, should he be confirmed by the Senate next week, is currently an assistant attorney general in the agency counsel division and assigned to the Department of Corrections. So it's a variety of backgrounds and perspectives. I think it gives some diversity of thought and a kind of balanced decision-making approach that focuses primarily on public safety, but also on trying to create the conditions for successful reentry into the community to keep our community safe.
Thank you so much. And such valuable information. I think just knowing that Amanda, Brett, Shanna, and Jennifer are all here to help understand that process. So definitely keep their contact information. That BOP victim at utah.gov is a great way to ask Shanna questions and things like that, or for the victim to utilize that to send things. So thank you so much. We really appreciate your guys' time. It's such a valuable information for everyone to understand this process after adjudication. So.
Thank you so much to all of you for the important work that you do. And I would say, I hope that seeing our faces here today helps you realize that when you have questions about a case and how it might be being handled or how we might handle it, should it result in a certain way at sentencing, we would absolutely be happy to field those questions and figure something out to the extent that we're able. So I hope that you'll reach out in any number of those ways because we would love to hear from you. It's important to us to make sure that we're serving the whole community.
Thank you so much. We really appreciate your guys' time. Thank you.
Thank you, guys.
Amazing information. I learn something every time, even though we've had you guys for other things. So thank you so much.
All right. Well, thank you so much, everyone. Have a wonderful day. Thanks for taking the time to listen to our presentation.
Thanks, everyone.
Thank you.
So our last presenters of the day, we are so grateful to have Sarah Condor and Molly Metcalf here with Salt Lake County Probation and talking a little bit about the process that can happen if the case, like a lot of you guys voted in the poll, would likely be that the defendant in our scenario would lead down to a Class C misdemeanor and be on probation as opposed to a felony and be in prison. So we wanted to have them kind of talk about what they do at the Salt Lake County Probation and some resources that you guys can be aware of. So I will turn the time over to you guys. Oh, and sorry, I'm going to